Hello everyone, and welcome to Virginia International University's MBA 605 auditing course. Today we're going to cover the idea of legal liabilities as covered in Chapter 5 of the text. And these are very important to the auditor since we live in a very litigious society. Our reports are the basis for many economic decisions that users make, and we can be held under various theories and concepts of law responsible if those decisions would have been made differently but for the results of our audit. So let's dig in and talk about a little bit of that today. So we want to understand the litigious environment in which CPAs practice. We want to explain and understand why the failure of financial statement users to differentiate among business failure, and audit risk has resulted in so many lawsuits. We want to use and understand the primary legal concepts and terms concerning accountants' basis for studying legal liabilities of auditors. Audit professionals have a responsibility under common law to fulfill implied or express contracts with clients. They are liable to their clients for negligence and/or breach of contract should they fail to provide the services or not exercise due care in their performance. Despite efforts by the profession to address the legal liability of CPAs, both the number of lawsuits and sizes of awards to plaintiffs remains high. Increased consciousness of the Securities and Exchange Commission, or the SEC, for its responsible for protecting investors' interests are one of the main reasons why there's a growing awareness of responsibilities of public accountants by users of financial statements. There's also a growing complexity of auditing and accounting functions caused by increasing sizes of business, globalizations of businesses, and complexities of business operations. The tendencies of society to accept lawsuits by injured parties against anyone who might be able to provide compensation regardless of fault, which is this idea of deep pocket concept of liability, has also contributed to the changed legal environment in which auditors operate. Large civil court judgments against CPA firms awarded in a few cases encourage attorneys to provide legal services on a contingent fee basis that offers the injured party a potential for gain when the suit is successful, but minimal losses when it is not. The willingness of many CPA firms to settle legal problems out of court in an attempt to avoid costly legal fees and adverse publicity rather than resolution through judicial process is another contributor to this proliferation of lawsuits. Judges and jurors have difficulty in understanding and interpreting technical accounting and auditing matters, and so we are already operating at a disadvantage in a court since on the one hand we have a party alleging some sort of damage by having relied on financial statements that have been audited and issued by accounting firms, and we have a court and a jury that's not knowledgeable or uneducated with respect to what is required as a result of that audit, all of which tends to work in favor of the damaged party and against the CPA firm. And here again, these just reiterate some of the items we talked about in the prior slide. So business failure occurs when a business is unable to repay its lenders or meet the expectations of its investors because of economic or business conditions. An audit failure, on the other hand, occurs when an auditor issues an incorrect audit opinion because it failed to comply with the requirements of auditing standards. Audit risk represents the risk that the auditor will conclude that the financial statements are fairly stated and an unqualified opinion can be issued when in fact they are materially misstated. So at the end of the audit, we say the financial statements taken as a whole fairly present the results of operations of the corporation, and that when in fact, because of some undetected error or because of some undetected fraud, they do not. And then the user of those financial statements makes some sort of economic decision based on that audit opinion, which in turn is incorrect. They can show that they would have made a different decision, and then this is where this idea of our liability then comes into play. That liability is then impacted by these different items. The standard of due care is often called the prudent person concept. Under a limited liability partnership or limited liability corporation, the liability for one owner's actions does not extend to another owner's personal assets unless the other owner was directly involved in the actions of the owner causing the liabilities. And CPAs, unlike attorneys, do not have the right to withhold information from the courts on the grounds that the information is privileged. Again, this idea of privileged information and the lack of that defense can often damage the CPA's case if it were to go to court. So here we have some terms related to liability. Ordinary negligence is the absence of reasonable care that can be expected of a person in a set of circumstances. And so what we're saying there is that the auditor was negligent in that they didn't even provide a reasonable level of care and attention to fulfilling their responsibility. Gross negligence, on the other hand, is the lack of even slight care, tantamount to reckless behavior that can be expected of a person. Constructive fraud is the existence of extreme or unusual negligence, even though there was no intent to deceive or do harm. And then we talk about fraud, and fraud occurs when a misstatement is made and there is both the knowledge of its falsity and the intent to deceive. These ideas of the legal terms that are related to contract law, we have a breach of contract, wherein a breach is the failure of one or both parties in a contract to fulfill the requirements of the contract. And we also have this idea of third-party beneficiary, and that's the one who does not have the privity of contract, but is known to the contracting parties and is intended to have certain rights and benefits under the contract. So, for instance, a bank that has a loan agreement with a client wherein certain covenants are made is a third-party beneficiary, in that they are known by the auditors, and they will rely on the results of the audit in order to continue. Other terms include common law and laws that have been developed through court decisions rather than through governmental statute, or statutory laws, which are laws that have been passed by the U.S. Congress and other governmental units. Then this idea of joint and several liability is the assessment against a defendant of the full loss suffered by a plaintiff, regardless of the extent to which other parties shared in the wrongdoing. And then finally, we have this idea of separate and proportionate liability, and that's the assessment against a defendant of that portion of the damage caused by the defendant's negligence. So we see the difference between separate and proportionate liability and joint and several liability. And so this table shows us 4 sources of an auditor's legal liability. That's liabilities to clients, obviously the people who are paying us to do the job. That's the liability to third parties under common law, and that's liabilities to people or to parties who use the financial statements that an audit opinion has been issued on, and this liability that has grown to them through common law, not through statute. We have civil liabilities, which are passed on to users of financial statements as a result of federal security laws. And then we have criminal liabilities, where we have an auditor is responsible for, should they knowingly issue an audit opinion that is incorrect. And then we have some examples of these different sources of liabilities. And so it's important to keep in mind that the most common source of lawsuits against CPAs is from clients. So the people who hire us to do our audit, the people who have responsibility for issuing the financial statements, the people who support us in the conduct of that audit are the ones who sue us most often. We do have certain defenses against these client suits. So the client sues us, and then we have to respond somehow with respect to what we did and why we shouldn't be sued. And some of those defenses include a lack of duty to perform, which means that the CPA firm claims there was no implied or expressed contract. There's non-negligence performance, which means that the CPA firm claims that the audit was performed in accordance with auditing standards. Even if there were undiscovered misstatements, the auditor is not responsible if the audit was conducted properly. We have this idea of contributory negligence, which exists when the auditor claims the client's own actions either resulted in the loss that is the basis for damage or interfered with the conduct of the audit in such a way that prevented the auditor from discovering the cause of the loss. And then we also have this idea that in order to succeed in the action against the auditor, the client must be able to show that there was a close causal connection between the auditor's failure to follow auditing standards and the damages suffered by the client. In defense of such litigation, the auditor would attempt to refute any connection. This defense is often called the absence of causal connection. And so we have another act that we need to be concerned about as auditors and that we should audit to, and that is the Foreign Corrupt Practices Act of 1977. And this act makes it illegal to bribe an official of a foreign country for the purpose of exerting influence or for obtaining or retaining business. So, and this is an important act, and so for companies that do business internationally, and we talk about the globalization of business, we find that auditors, through different audit steps that we'll talk about later, have to be comfortable that the company or their client hasn't violated this Foreign Corrupt Practices Act. The Sarbanes-Oxley Act of 2002 requires the CEO and CFO to certify the annual and quarterly statements filed with the SEC. Management must report its assessment of the effectiveness of internal control over financial reporting, and the auditor must issue an opinion on the effectiveness of internal control over financial reporting. And we'll talk about the idea of this integrated audit, that is an audit of internal controls over financial reporting and the financial statement audit, and how the reports, the different options available to auditors on how these reports that assess both the internal control and the financial statements themselves can be issued. But this Sarbanes-Oxley Act requires that we have both an audit of internal controls and an audit of the financial statements, and it requires that management, that is senior management, the CEO and CFO, are on the line for these internal controls, their effectiveness, their execution, and their adequacy to address the controls around financial reporting. And this Sarbanes-Oxley Act also makes it a felony to destroy or create documents to impede or obstruct a federal investigation. And this largely stems from the debacle around the Arthur Andersen's involvement in the Enron scandal from many years ago, where Arthur Andersen essentially destroyed documents that would have been of value to the government's investigation of Enron. And so this provision of the Sarbanes-Oxley Act was really a reaction to those firm-specific, Arthur Andersen no longer being in business now, but those firm-specific actions of destroying documents. And so, in order to maintain some level of self-regulation, we find that the accounting profession is constantly responding to issues around legal liability. And so we're constantly setting standards and revising them to meet the changing needs of auditing, partly as manifest through lawsuits. And we are trying to educate investors and others who read financial statements as to the meaning of the auditor's opinion and to the extent and nature of the auditor's work. And so with that increased understanding, the expectation is that users of the financial statements will assume more responsibility on their own part. Although, again, I get back to this idea of the deep pocket concept, where if users suffer a loss and they can somehow take those damages back to reliance on the financial statements, they are creating a path for holding the accounting firm liable for those decisions. And so here that we're talking that our profession must police its own membership. The AICPA and the Public Company Accounting Oversight Board have made progress in dealing with problems of inadequate CPA performance, but more rigorous review of alleged failures is still needed. Since the 1990s, several changes in state and federal laws have favorably impacted the legal environment for the profession. The passage of the Private Securities Litigation Reform Act of 1995 and the Securities Litigation Uniform Standards Act of 1998 significantly reduced potential damages in federal securities-related litigation by providing for proportionate liability in most instances. So we ask ourselves, how as individual CPAs are we able to protect ourselves from legal liabilities? And this shows an umbrella of actions we might take by an example of dealing only with clients possessing high integrity. Hire qualified personnel. Follow the standards of the profession. We want to maintain our independence. A CPA firm needs procedures to evaluate the integrity of clients and should disassociate itself from clients found lacking in integrity. Also, independence requires an attitude of responsibility separate from the client's interest. So these are ideas and examples of what we can do as professionals to shield ourselves somewhat from legal liability. Again, just these examples of how we can shield ourselves from legal liabilities that we talked about in the last slide. We also want to make sure we don't overlook this idea of performing quality audits. Document our work papers properly so that if the work papers become subpoenaed and end up in court, we can show that they were documented in accordance with professional standards and that the conclusions drawn from the audit work are fair and reasonable conclusions. And we want to exercise professional skepticism. That is, we are auditors and we are in trying to assess the fairness and reasonableness of the reporting, and so we have to have some healthy skepticism in the process. So auditors are often liable when they are presented with information indicating a problem that they fail to recognize. In that case, we need to strive to maintain a healthy level of skepticism so that we can recognize misstatements when they occur or exist. And so this covers our discussion from Chapter 5 of Legal Liabilities. I encourage you to go back and read the chapter. Again, these discussions are not intended to substitute for reading. Become familiar with the concepts and the defenses. These are prime areas for the CPA exam if you're ever interested in taking that. And if there are any questions on it, please don't hesitate to email the facilitator those questions. So thanks for your attention to this, and we look forward to going into our next topic, which is the audit responsibilities and objectives covered in Chapter 6.